Good morning. Man, it's exciting to see all of you here. I'm Matthew Brogdon. I'm the Senior Director of the Center for Constitutional Studies here at UVU. I want to welcome you on behalf of the university, on behalf of the Center for Constitutional Studies, on behalf of the guests we've got here. Today is our celebration of Constitution Day. Constitution Day, of course, it's celebrated nationally on September 17th. Anybody know why that is? Why September 17th? You can shout it out, it's fine. It was signed. Good. The Constitution was signed. Of course, that didn't make it a Constitution, right? Signing the Constitution, 39 people signed the Constitution from a bunch of different states, actually only from 12 of the 13 states, but it wouldn't become a Constitution until it was ratified, and that process took, anybody know what year the Constitution was ratified? it goes into effect. 1789 is a really important year. It's actually ratified in 88 when we have the first elections. That's when our 4-year cycle starts. So you can count back in 4-year intervals from 2024 and get back to 1788. And then the first Congress sat in 1789, and George Washington was inaugurated that year. So that's why we celebrate Constitution Day. We celebrate it because the Constitution was successful. We wouldn't be celebrating September 17th if it hadn't been ratified. And plenty of people didn't think it should be ratified, actually. So we had to have a debate over the Constitution, and we're still having robust debates over what our constitutional order should look like. Now, our Constitution Day is a little different than what you'd find around the state. We quite often for Constitution Day are talking about the Constitution, right? One Constitution, the Constitution we've had since it was written in 1787 and ratified in 1788 and started operating in 1789. And by the way, we had to add the Bill of Rights. That didn't come until 1791. They're ratified. So we've had it for that long, and usually the Center for Constitutional Studies is doing an event like this in the middle of September to celebrate something from that Constitution, but this year is a little different. This year we're celebrating state constitutions, what we might call the state constitutional tradition. And unlike the federal Constitution, which was created over 200 years ago, we've amended it 27 times. That seems like a lot, until you consider that Utah's amended its constitution 24 times just in the last decade. So, constitution making is a thing we did in the founding with a capital F, but states are founding and refounding their constitutional orders constantly. And we spend quite a bit of time in the Center for Constitutional Studies studying state constitutions. Now, anybody have any idea what the longest written constitution in the world is? It's an American state. Anybody know which one? Did somebody said Alabama, right? I heard Alabama. It is Alabama. Alabama started out with a constitution that was 200,000 words long. I have a book manuscript, an academic book manuscript. It sounds like something you'll be thrilled to read when it comes out, right? Sitting on the back of my desk, it's about this thick. It's got almost 300 8.5 by 11-inch double-spaced pages. It's just under 100,000 words. That means the Alabama Constitution would be 1,200 manuscript pages if it was an academic book. That's like, I'm pretty sure, I don't even know if War and Peace is 400,000 words. I'm not really certain. Tolstoy might not have hit 400. So constitutions can be very long. State constitutions can be very long. Some of that's because state constitutions have operated much differently than the federal Constitution. But I hope when you walk out of here today, you're going to hear from a very important guest here in just a moment for our keynote speech. To whom I'm going to introduce you in just a moment. But I hope when he gets done talking to you, you understand why it might be worthwhile to read a state constitution, even if it is longer than a Harry Potter book. Okay? We want to press home the value to you, and part of that is because your state constitutions are accessible to you. There's a realistic prospect. Actually, it is almost a certainty. Well, I know it's a certainty of the next election. When you turn 18, you will get to vote on a constitutional amendment, maybe not to the federal constitution, but in your state. You even have a realistic possibility of participating in an effort to pass a constitutional amendment and being successful in your state. So we really need to understand the state constitutional tradition and why it's important. And I'll leave the rest of that explanation to our guest, whom I'm excited to introduce. Chief Judge Jeffrey S. Sutton. I just put an R. I just changed your middle name. Sorry about that. Jeffrey S. Sutton. It felt like it needed an R in the middle. You know, I don't. But the Honorable Jeffrey S. Sutton is the Chief Judge of the U.S. Court of Appeals for the Sixth Circuit. That sounds like a mouthful, right? You may not know what the Sixth Circuit is. Let me tell you. So in between, if you commit a federal crime, okay? Let's just pretend. You're not actually going to do this, to be clear. If you commit a federal crime, you'll be tried in a federal district court. That's where they have juries, right? And if the state does something unconstitutional to you while you're in that trial, you might eventually get to the Supreme Court to try to get your conviction overturned because maybe they did an unreasonable search and seizure or coerced a confession or something, right? Or imposed some really strange, cruel, and unusual punishment like public humiliation. But in between, you're going to stop at a federal appellate court, right? And in this case, one of those courts is the Court of Appeals for the Sixth Circuit. The Sixth Circuit has jurisdiction over the states of Michigan, Ohio, Kentucky, and Tennessee. Did I miss any? You got it? I got them all four, over 4 states. So if you happen to be a criminal convict or you have some other lawsuit in one of those states and you have to appeal your conviction, you might get to at least watch your lawyer argue in front of Chief Judge Sutton. But we're confident this is not going to describe any of the people in the room at the moment. So Chief Judge Sutton is here to talk to us. He has been on the Sixth Circuit since 2003, so for 20 years. He's currently its Chief Judge. In fact, he's just come to us from the Judicial Conference of Senior Circuit Judges, which meets in Washington with the Supreme Court to make policy and talk about how best to run the federal judiciary. Now, Chief Judge Sutton is distinctive because in his career and in his law teaching, which he does at The Ohio State University and at Harvard Law School, he teaches about state constitutional law. In fact, he's written a book called 51 Imperfect Solutions, which is about America's 51 constitutions, not just its one constitution. And more recently, he's written a book called Who Decides?, which is about states as laboratories of democracy. So I am excited to introduce Judge Sutton. He's going to talk to us today about state constitutions, and I hope you will give him a very warm welcome.
Thank you, Professor Brogdon. It's a real honor to be with you. But you're so blessed to live in this neck of the woods. I live in Central Ohio. It's a great state. I'd say a better state, but yours is beautiful, and I would say maybe a little more beautiful. So it's really been fun to be here. You know, I have to say I give variations on these talks in lots of places, and for some reason I'm a little more nervous with you. And I think I'm realizing that the 2 hardest audiences I've ever faced is I was originally a high school history teacher. I did that for 2 years and, forgive me, sold out and went to law school. And then as a lawyer, I argued 12 cases in the U.S. Supreme Court. And I always tell people the best practice I ever got for arguing in front of the U.S. Supreme Court was teaching high school students. And now I have to say it's not the compliment you might think it is. It's actually a slight put down of the court. Turns out the court's attention span is about the same as yours. Turns out justices like to talk to each other while I'm talking. So there's a little commonality between the two. But it is really great to be with this audience. So I do want to talk about state constitutions, and I'll start with two stories. One, a story about teaching state constitutional law, and then a story about writing a book about state constitutional law. So the story is pretty easy to envision and imagine, given what we went through the last few years. So I teach a class on state constitutional law at Ohio State's law school, and back in the fall of 2020, if you remember, COVID hits us in March of 2020. We shut down everything, all virtual learning for the rest of that semester. Very difficult to run a school in the fall of 2020. So at Ohio State, they did what I suspect most of you saw, which was schools trying to be all things to all people. What did that mean? It meant the professor could teach from home if they wanted, virtually, or they could show up live. The students could show up in class, or they could do it virtually. So I'm getting ready for my first class, the fall of 2020 at Ohio State. I'm in a room not quite this big, but it's really humorous because they were so freaked out about the spread of COVID. My class had like 22 people, and instead of 6-foot spacing, it was like 100-foot spacing. Anyway, so they're spread all over this hall, and I'm behind the mic, and they have to get my laptop so I can't move. The students virtual are up on the screen, so you got to get that there, and then all the students in front of me have their laptops so they can be seen by the students at home. Kind of a real technological difficulty. They get the whole thing sorted out. Class starts at 5. It's just a few, 15 seconds before 5 o'clock, and I realize I've made a horrible mistake. We, of course, were all masked up, and it's difficult to wear a mask for a long time. I'm pretty confident you know that. Try teaching for 2 hours with a mask. Your throat gets really dry, so your real friend is a bottle of water. And I realized I had not brought a bottle of water, but then I remembered Ohio State had given us this kind of COVID protection bag, which had, of course, Ohio State masks, wipes, instruction, how to avoid getting COVID, and so forth. And lo and behold, in the bottom of the bag was a 6-ounce bottle of water, manna from heaven. So I quickly open it, take a big gulp, not water. So it was sanitizer. Now, proving that you have a very altruistic speaker today, I did not spit it out on the people in the front row. I swallowed this very big swig of sanitizer. Now, I'm a very quick-thinking person, and I immediately went to 7th grade science and thought, okay, I remember this. I was listening that day. There are 2 types of poisons. One you extract, and the other you dilute with water. And so I just didn't feel like the extraction route, and so I thought, let's go with dilution. So I quickly, now this is awkward because to give you a sense of the scene, it would be like my leaving the audience right now. You're like, well, why is he leaving? I thought about telling them what had happened, but it was the first day of class. And what you might not know about college and law school is you don't have to take anybody. Like in high school, you kind of have to take a lot of teachers. But in college and high school, you can opt for another class. And they have what's called an add-drop window for like 2 weeks. And I thought if I told them I had just drunk some sanitizer, they probably wouldn't want to take the class with me. Like, who takes a class from a guy who drinks sanitizer? It's not like an overwhelming endorsement of intelligence. So I calmly, as if nothing was going on, walked out of the classroom, and remarkably, quite negligently, I must admit, Ohio State still had the water fountains on. That was a great COVID spreader place. Drank lots and lots of water, wandered back into the class, again, didn't tell anybody, and taught the rest of the class. Now, just a couple things about drinking sanitizer. It's very hard to get the taste out of your mouth. I didn't die, so that's a plus. Apparently, the dilution approach worked. Some of you, maybe with a mischievous streak, were saying, well, did it make your head a little foggy? Like it's alcohol after all. This was like a lot of high proof alcohol. Maybe that either took the edge off the class, that's one way of thinking about it, or fogged up your teaching. Back to 7th grade science, I don't quite understand this, but there are 2 different types of alcohol, and this is the one without those properties. This will just kill you. It won't make you lightheaded or whatever else alcohol does for people. So Professor Brogdon gave a very warm introduction, and you have to wonder if he's rethinking it at this point, because this is clearly not the best speaker they've ever gotten for Constitution Day, and surely not the most intelligent. Now let me tell you a story about writing books about state constitutional law, mercifully a shorter story. It's difficult to write books about state constitutional law because it turns out most people are not interested in state constitutional law, and this story exemplifies the problem. I was coming out of church. It's a Sunday. I just finished my first book, 51 Imperfect Solutions, total page turner. And a doctor friend of mine, retired doctor friend of mine, sees me as I'm coming out and says, "Oh, Jeff, I heard you wrote a book. That's so exciting. Good for you. Is it an autobiography?" And I said, no, it's not really. He says, "Is it a mystery? I love mysteries." And I said, no. And then a little frustrated, "Well, what's it about?" And I said with far too much enthusiasm, "State constitutions." Well, Dick Briggs is a very polite, kind of elderly, formal guy, and he had no idea what to say next. So it was a long pause, and he looked at me and goes, "Are you sure it's not a mystery?" And I do think that captures the problem of those of us on this side of the room that have decided to devote our careers to state constitutional law. So I'm going to orient my talk. I'll probably keep an eye on the clock for about 30 minutes, maybe a little less, and I'll see if I can get through 10 mysteries of state constitutional law. So mystery number 1 is a real head scratcher for me as an American. Like you, we Americans take great pride in our founding story, our origin story. We love our history. I think we're rightly proud of this great American constitutional experiment, so I'm not second-guessing any of this. What does baffle me is that we simultaneously celebrate American history and the great American Constitution without having any knowledge whatsoever where this document came from. That seems like a puzzler, right? I mean, if you care about history, you'd go back to the start. You don't start with Job, you start with Adam and Eve. I mean, in America, we start with Job somehow, which that's a depressing way to start, by the way. But anyway, that's actually true when I think about some of my views of federal con law, but that's for another day. The Adam and Eve story, when it comes to American constitutional law, starts before the fabled summer in Philadelphia in 1787. It starts before it's ratified in 1788. It starts before it goes into effect in 1789. The American Constitution story starts in 1776. When we break free from Britain, the colonies, now states, have got to figure out what this government is going to look like. It would not have made a lot of sense just to stick with the British rules, having just started a war, a revolution with Britain. So that's the real era of constitution writing. In fact, one of the best American historians, Gordon Wood, says the greatest era of constitution writing in American, indeed world history, is before 1787. It's 1776 up to 1787. That's where the innovation is. And by the way, you actually know many of the authors of those documents. I mean, John Adams wrote the Massachusetts one, George Mason. I mean, some of our great early American founders cut their teeth on writing the state constitutions. And what's amusing to me, I mean, this is one thing high school students know something about, I hope, is plagiarism. And we're watching you with the ChatGPT thing. That's plagiarism, by the way. Another digression as a former teacher. But the reality is there's very little in the 1789 federal constitution that didn't originate in a state constitution. The same is true of the Bill of Rights. If you go to the Bill of Rights ratified in 1791, the first 8 provisions, all of that is cut and pasted from the early state constitution. So the first mystery here is, how did we forget? I mean, if we care about our American story, we should really embrace the state constitutions, which really are the blueprint, the source code of our great federal constitution that we celebrate today. Why did we forget? Mystery number 2. As proved by the fact it's called Constitution Day, singular. It should be Constitutions Day, either 51 constitutions. I'd like to include tribal constitutions. That gets you beyond 51. But at all events, it shouldn't be singular Constitution Day. So why did we forget? How did this happen? Well, I have to say part of the blame goes to people like me, former high school, middle school teachers. In teaching civics, 13-year-olds roughly, government, high school students, even college, I dare say, we have reduced the story of American constitutional law to a single story, what's sometimes called the peril of a single story. Well, you already know the problem of a single story in social interactions. Think of the first day in school, and there's someone new to the school, and you make your quick judgments. Oh, they're really good looking, you say they must be arrogant. In my case, I didn't like tall guys because they were bigger than me and they would likely make the basketball team and I wouldn't, so I'd have quick assumptions about them. But happily, the school year goes on and you learn what the danger of the single story is. That, well, no, it turns out when you get to know this person, they're actually not arrogant, or they're actually not as shy as they seem, or they've got a great sense of humor. Well, that's what happens when you look beneath the first layer of American constitutional law and see that there's more than one constitution and more than one court protecting our liberties as Americans and protecting equality. One problem with the single story, it's true for interaction with individuals, it's true for American history, it leads to myths and legends. One of the great myths and legends in our country is that the U.S. Supreme Court is always right. This great guardian of American liberty and equality is always right. Now, there is some evidence of very heroic stories at the U.S. Supreme Court, which at least supports part of the legend. Take Brown versus Board of Education, eliminating segregation by race. But it's a myth to say these 9 individuals in the U.S. Supreme Court always get it right. Buck versus Bell, the eugenics case is a great example. Dred Scott led to the Civil War. Plessy versus Ferguson, of course, is the very case the U.S. Supreme Court had to overrule in Brown versus Board of Education. Another myth that grows out of the single story is that the myth that the states aren't up to it, that state court judges aren't as good as federal judges, that state governments can't be as progressive, idealistic, innovative as the federal governments. That's just completely false if you look at it carefully through the lens of American history. You'll see lots of stories where the heroes of the story actually are the state courts. I mentioned, I'll just pause on the eugenics story. It happened roughly 100 years ago. It's a striking story. In the early 1900s, scientists thought they had figured out a way to eliminate the problem of people having mental, emotional, and even to some extent physical disabilities. They thought it was all a function of genetic steering. All you had to do is if someone had a mental disability, for example, you sterilize them. That way they can't procreate, and that way you would eliminate the risk of someone with that disability being born. Now, believe it or not, that was a movement of the elite. It was centered at Harvard, Stanford, Teddy Roosevelt, our president, Oliver Wendell Holmes. Some of the great Americans in this country were huge proponents of the eugenics movement. Confirming the point that it was a movement of the elite, the U.S. Supreme Court in Buck versus Bell permitted it, said the U.S. Constitution had nothing to say about involuntarily sterilizing Americans. Now, that's the federal side of the story. The heroes of that story are in the state governments and state courts. When those sterilization cases went to the state courts, The states got it right. The states invalidated the laws, prohibited the involuntary sterilizations, and in a lot of cases, it was state governors that refused to enforce these laws. Sometimes it was the superintendents of the institutions where the individuals were housed that refused to involuntarily sterilize individuals. Here's the key point. You put all your eggs in one basket in protecting liberty and equality, you will eventually be disappointed. If you're going to put all your faith in the U.S. Supreme Court, you're going to be disappointed. You put all your faith in the U.S. President, Congress, you will eventually be disappointed. It's a fallen world. The best thing to do is spread out responsibility for these really critical features of American life, having state and federal governments doing the protecting. Okay, so mystery number 3. Now, let me try to be concrete about how state courts and state constitutions might be relevant to you. And this is maybe the most important thing I'm going to say today. So if you don't have to listen to anything else, just listen to this. I've been in your shoes. I've looked at you before as a high school teacher. I know the odds here of you're listening to everything. But this is the one thing I want you to listen to. If there is a state or local law that you don't care for, or sadly, a friend, family member getting prosecuted by state or local governments, a key message of what I'm saying is that you have 2 chances, not just one, to get rid of that state or local law, to stop that state or local prosecution. So I told you earlier that every individual rights protection in the U.S. Constitution appears in our state constitutions. That's clearly true in Utah. That means if the U.S. Supreme Court puts up a big red stop sign, so I'll give you 3 examples of pretty high-profile cases. In a case called Dobbs, they said the federal Constitution does not protect the right to abortion. In the case called Rucho, they said the federal Constitution gives you no right to stop political gerrymandering, no matter how much you dislike it. In a U.S. Supreme Court case called Smith, they underprotected the right of free exercise of religion. So those are all 3 cases in which the U.S. Supreme Court puts up a big red stop sign, will say under-enforces the federal guarantee. You're now allowed to use the Utah Constitution to get the very relief denied in the federal courts. More personally, you can come to my court and lose, and then go to state court and win under the state constitution. Now, this is a real case I had early in my tenure. It was kind of I guess it was a father-daughter project. This high school in Kentucky decided to have a new dress code, pretty strict, and apparently quite a bit stricter than the high schools here, because it said no blue jeans. So a lot of you would have been in non-compliance. This no blue jean policy really agitated the father and the daughter. It turns out the father was a lawyer, more later, half equipped to protect his daughter's rights. So in this father-daughter project, they filed a lawsuit in federal court and said they had a First Amendment free speech right to wear blue jeans. And free speech is not just about talking, it's about expressiveness, free association. And the idea behind the daughter's lawsuit was, hey, I'm kind of showing I'm pretty hip here. This is, instead of having to just tell everybody I'm hip, I prove it with my clothes. And you could say that we see these cases with T-shirts. People want to wear certain T-shirts with language. Anyway, I wrote the opinion. I'm a pretty old-fashioned, stingy guy, and I said, no. The federal free speech clause does not give you a right to wear blue jeans. Now, the father, a lawyer, was only half equipped to protect his daughter's rights. Isn't that terrible? He could have gone, but did not go to the Kentucky courts and said the Kentucky free speech clause protects these rights. So there's a really concrete example. You lose in federal court, it's not the end of the story. You can convince the state court to do just what was denied to you under the federal Constitution. Mystery number 4, I'm getting there. Are American basketball players smarter than American lawyers? Now, this is really easy, and let me illustrate the point pretty concretely. Let's say, now I know some of you are not basketball fans, but bear with me. If you can't get this, you've got some real problems. This is a pretty easy account to understand. Most of you have heard of the NCAA basketball tournament every spring, March Madness and all that. 64 keeps growing, best college basketball teams, Division I. And they start this competition, which ends with a national championship, 9 o'clock East Coast time anyway, on a Monday. And it's the two best teams trying to be the winner of the NCAA basketball tournament. Let's say next spring, the finals are UVU versus BYU. Maybe implausible, but that's why it's called a hypothetical. The game is tied with very little time on the clock. The UVU star player has the ball. He drives the lane. He's fouled badly in the act of shooting. The ball does not go in. And under the rules of basketball, he gets a two-shot foul. Clock's ended. The game is tied. If you are a UVU fan, this is not a bad place to be. All the player has to do is make one shot, you're national champions. Now let's say, in my hypothetical, that the UVU player misses the first shot and does not take the second shot. The coach says, let's just not take it. Let's go to overtime. And then they lose in overtime. Now, this would be a 30-30 ESPN special forever. The coach would lose his job. The player would have to go into some kind of defense hiding program because the UVU fans would be tremendously upset that he didn't take this one extra shot to win the game, win the national championship. Forgive me, but I assume that would be your first national championship in men's basketball. Maybe I'm wrong about that, forgive me. But pretty extraordinary thing to do. And all of you are saying, that could never happen. No one would be that stupid to do that. And in one sense, you're right. I don't think there's ever been a basketball player going down to CYO fourth grade basketball who got a two-shot foul, missed the first shot, and did not take the second shot. As implausible as all that is, we've got a lot of explaining to do when we shift from American basketball to American law, because every day of the week, American lawyers just take the one shot. I illustrate it with my Blue Jeans case. The father just filed one lawsuit under federal free speech clause. I'll illustrate it now, two cases to kind of show how this could work and compare federal courts and state courts. I'll do criminal law to illustrate it, and I guess the message here is don't do drugs because they're both drug-related cases. The first case is a federal crime. I can't remember, this was early in my tenure, I can't remember if this was cocaine or meth, but it turns out I think they're equally bad. And it makes reasonably smart people incredibly stupid, as illustrated by this fact pattern. So these three people were engaged in binging on something, cocaine, meth, whatever. And in their second day or so, the fellow that had done most of the supplying of the drugs got paranoid about where the rest of the drugs were. He accuses one of his friends, a woman, of stealing them. She denies it, and kind of straight out of the movies, gets her in a car with his buddy. They drive her to this tree in the woods where supposedly they'd been hidden. She says, I don't know where they are, I don't know where they are. He takes out a gun, and I guess this is what people in the mob do, shoots her right through the shoulder, right? So it hurts, obviously, but you don't usually die. She still doesn't say where they are. Keep in mind, they've been doing this for 2 days. Is it possible they've already consumed all the drugs? I'll let you decide based on the next part of the story. So he still hasn't gotten her to confess where the drugs are. So now he drives her with his buddy to a lake. And again, they watch these movies and they don't know quite how to implement what they've seen in the movies. They put her in a rowboat. The two of them row her out to the middle of the lake. They put cement blocks on her. They throw her into the lake. One problem with this story: the lake is 4 feet deep. So now she stands there, hard to move with cement blocks. They still have the gun. They try to fire some shots. She's bobbing and weaving. They miss her every time. Don't do drugs, it makes you stupid. They run out of ammunition. And in a conversation that was not recorded for history, they must have decided, what do we do next? They decide to put her back into the boat, which had to be really hard with the cement blocks. I've always tried to imagine how they did this, whacked out on drugs. And anyway, they get her back into the boat. They row her to shore. They get her out of the boat on the beach, and then the two of them pass out. She picks up the cement blocks, walks to the nearest road, flags down a car, and becomes a very good witness in their attempted murder trial. So, now that case, she's charged under federal law. And this is the key point of that story. You only get one shot. Well, bad word in this setting. You only get one attempt to get relief in this setting because it's the federal Constitution and the states cannot limit federal law. That's the supremacy clause, but the federal Constitution controls and federal law controls over state law. So this fella did not have a second shot, and when he lost in our case, that was that, and he had to stay in jail. But now let me give you a case from Utah. Again, don't do drugs. This is a fella from, I don't know if it's Salt Lake or not, but the name of the case is well known, so I can say his name, Edward Streif. And poor Edward Streif had a drug addiction, and the day he was trying to get drugs to satisfy this addiction, he happens to go to a drug house where the police are already monitoring what's going on. Edward Streif walks out of the house, and the police stop him. Now, they don't have any right to arrest him at that point because he's done nothing wrong. You know, he could have been the mailman. He could have been a neighbor. He could have been someone just, raising money for some cause. It's not proof of crime that you walk into a drug house or where people are selling drugs. But they ask his name. He says Edward Streif. They go into a database and they realize that Edward Streif has some outstanding arrest warrants. And they say, now we can arrest you, and most importantly, now we can search you. And of course, he does have drugs. He's arrested. Now, this is a story of a very good lawyer. I would not say one half equipped to do a good job, although in this case, it would have helped to do something else. But proof this was a good lawyer, she challenges the search on federal, what's called the Fourth Amendment, search and seizure grounds. And she wins in state court, because it's a state court prosecution. And she wins in the Utah Supreme Court, 5-0 decision, very distinguished justices on the court enjoining the decision, but only on the federal ground. She does not bring the UVU second shot. What happens? The state appeals to the U.S. Supreme Court. It gets reversed. Edward Streif sat in a state jail because his lawyer did not know about the second shot. Now, I can't guarantee you the Utah Supreme Court would have granted relief, but it doesn't seem like a bad prediction given that they'd been 5-0 the first time around. But I gotta believe if you're Edward Streif, you would like to know whether that was a possibility. So this second shot really can make a difference. Next point, keep an eye on the time. I said there are two shots. In comparing it to basketball, they seem like two totally independent things, right? I shoot once, my odds are 70% of making it. I shoot again, 70%. You get two shots, the odds are decent, you'll make one of them. Does it work the same way in American constitutional law? Well, the reality is it's a very good analogy. The Utah courts have a lot of authority to do different things with their constitution from what the U.S. Supreme Court does with its. Let me just give you another way of thinking about it. Just because Congress decides to do something doesn't mean the Utah legislature has to do the same thing, or maybe they could do something different. The exact same thing is true with courts and state constitutions. Now, I've got the teachers with me, so I guess I can't actually make the assignment, but I'm gonna make the assignment. I can't enforce the assignment, except if you have a conscience. I've given a speech here for free. I frankly think you owe me something. And here's what I want. I don't want money, I don't want anything, I want one thing. Just 5 minutes of your time. I'm giving you like an hour. I know you're saying Judge, we're never getting this hour back either, so don't use the time thing on us. That's not helping. I get that point. I just want 5 minutes, all right? So I think you have a conscience. 5 minutes tonight. Go online and just punch in Utah Constitution and look at Article 1. Well, it's where all the rights are. Declaration of Rights, it's called, sometimes Bill of Rights. Just spend 5 minutes reading the rights part of the Utah Constitution. You will be stunned to see so many rights you did not know you had. You'll be surprised to see rights that look like the federal one, but are written in different language. So the first thing going on at the Utah courts is you've got a different document. It's got a lot more words, as Professor Brogdon said. It's got a lot more provisions, frankly, a lot more opportunities to get relief for something you might need. That's a pretty useful thing. The other thing, there's actually lots of reasons I could go on, but let me just give you a second one that I think illustrates why this second shot, this second bite at the apple, can be super productive in getting things you want. History really has an impact on what constitutions mean. It impacts what the federal Constitution means, and it impacts what the Utah Constitution means. A great trivia question would be to ask, what are the 4 states in this country that were founded by religious dissenters? In other words, but for persecution on the basis of faith, these states probably wouldn't be independent states in those particular geographical territories. So the 4 states are Rhode Island, Pennsylvania, Maryland, and I think you know the 4th, Utah. So that's really central to Utah history, the persecution primarily faced by members of the LDS Church. If you're in the Utah Supreme Court and someone brings a free exercise challenge and the federal courts have rejected the federal claim, do you not think the Utah judges will pay attention to Utah's history in figuring out what free exercise of religion means? That would seem astonishing to me. The beautiful thing about state courts and state constitutions is they not only can account for that history, they're encouraged to account for that history. That should make them proud. The U.S. Supreme Court can never do that, or at least should not do it. The U.S. Supreme Court should not be premising the meaning of a national guarantee on the basis of the experience of 4 states. The Utah Supreme Court, by contrast, can customize the meaning of the Constitution to account for that unique experience. All right, so I'm really running out of time here, Matthew. I've got so much to say. All right, let me just I'm not going to get to every mystery, but let me just do a couple quick ones. Those of you who have taken American history by now probably are thinking, well, let me give you one pushback on this whole federalism, state courts, states' rights thing. Haven't states' rights been terrible in American history? Isn't that something we should pause over? It's a really great point, not lost on me, and I have 2 answers to it. Answer number 1, if the U.S. Supreme Court says no, you've got nothing else. So whatever you think about American history, you might want to take that second shot. But thing 2 is it's exaggerated. It's true we have Jim Crow, it's true we have Plessy and Dred Scott, but there are lots of state court stories, the eugenics one comes to mind, where the heroes of the story really are the state courts and state constitutions. So don't fall into the trap of thinking state rights, favor one side or the other. In fact, that would be my next point. State constitutions don't inherently favor anybody. They're not blue, they're not red, they're not Republican, they're not Democrat, they're not conservative, they're not progressive. They're whatever the people of a state want to make of them. And so it's kind of one of the few things in American government that truly is neutral. And I'll finish with my last point. Why would state constitutions be good for America circa 2023, right now in American history where we're living through some really polarized times? Well, one way to illustrate the advantages of states, federalism, state constitutions is actually to go back to where I started, COVID. The COVID pandemic really illustrated the value of federalism. I can illustrate that in 2 ways. it was really quite remarkable to put together a vaccine as quickly as we did. Let me just tell you, I don't think Utah and Ohio were going to get that done on their own. That was a project for the national government. It had the resources to really do in a sufficiently big federal agency to get that done. And now I'm going to do one other thing this is going to be worth your time. This is the second time to listen, and maybe this is the one time for the teachers not to listen. I can upgrade every paper you write in political science and history, every exam essay you write, political science and history, from high school through college, if you do just one thing. Start out by saying, you know, this reminds me that the biggest issue in American history and American government is what should be national and what should be local. There's never been a teacher that won't be impressed by that. In fact, some of them will be so impressed they'll go and write their own paper on it. That is the issue at every point in American history. What should we nationalize and what should we keep local? We just keep doing the same story with variations throughout history. The COVID pandemic proved it. Clearly, the vaccine was a national concept. That was something for the national government to do. It's not as obvious that the national government should be in charge of everything when it comes to masks, vaccines, and other emergency protocols. And I can illustrate that, and I'm not picking on anyone. It was very hard to be in government during the pandemic. But one governor in one state, as early spring of 2020, as hospital beds were filling up, was trying to figure out, what do we do? Where do we find more hospital beds for these people with very serious COVID symptoms? And what this one state did is they moved patients that were over 55 to nursing homes where there were extra beds. Now, it turned out, they didn't realize that at the time, that was a very bad idea because the most vulnerable population when it came to COVID was the elderly. And what is it about nursing homes? They have mainly the elderly. Imagine if the President of the United States in spring of 2020 had said, here's what we're going to do across the whole country. We're going to move everyone over 55 with COVID in an emergency room to the closest nursing home. I mean, the number of people that would have died with that decision is astonishing. What does that prove? When you're not sure the right answer to a problem, it's a great idea to use smaller governments to try their hand at it till you figure out what works. And until you know what works, it is not a great idea to nationalize things. And so I think ultimately COVID really captures the pros and cons of federalism, and that sometimes the very best way to find out whether an idea is worthy of prime-time nationalization is actually to try it out in the states and see what works best, and if it does, then you can nationalize it. Okay, so it's been great to be with you. I'd love to get questions from you on anything law-related, COVID-related, UVU-related, basketball-related, and high school teaching-related. I think we've got mics somewhere. There's a mic here, and there's a mic there, so you got to maybe go to in between the rows. If you have a question, raise your hand, and it's back to teaching. Okay, the woman there, you got to walk over to the mic. Oh, perfect. Just what, ideally. Here she comes.
Did you ever end up telling your college students that you drank the hand sanitizer?
That's good for you. I know, and there's so many funny things about that. Thing number one is that's the only thing you're going to remember. And you've been thinking about that the whole time, which proves the danger of a very good story. I did tell them, and I tell every class that story. It's too funny, and I think, and I felt kind of bad. It seemed fraudulent. Isn't it slightly fraudulent not to disclose how stupid you are? So I felt guilty about it, so I told them, and from then on, and so far it hasn't hurt enrollment. I think I have other problems that could hurt enrollment more. Maybe that's a bigger issue. Oh, that's the only thing you're going to remember. That cracks me up. Okay, yeah, over there in the back, yeah.
So with, you going to hold it for me? Oh, okay. With some of the stuff we have happening right now in regards to the political issues, specifically with one presidential candidate's ability to be on the ballot in certain states. And I think there's 11 challenges right now to his, former President Trump's ability to be on the ballots in certain states. Are there issues in state constitutions where if the federal government rules one way, where states will be able to make the decision for themselves whether he's allowed to be on the ballot or not? And how do you see this playing out in your legal expertise?
Yeah, so I'm a sitting federal judge, and I'm exactly the wrong person to answer this live with these cases moving through the system. But I will say it's a really good question, and good for you for paying attention to what's going on in the country. It's such a challenging time. But the thing that is so fascinating, Professor Robert Williams spoke yesterday, and he spoke on this exact point, and he is the real expert. Professor Williams has been doing this for 50 years. And what's so striking about our federal elections, let's just pause for a second. You wouldn't be surprised that with state elections for governor, courts, legislature, that the Utah Constitution's rules and the Utah law rules govern. That makes sense. It's Utah officials. What's amazing about the federal Constitution is that it delegates most responsibility for federal elections to the states. And that is just astonishing, and that's why the question is such a great question. The very complicated answer is to go read a case called Moore versus Harper. By the way, classic teacher move. I don't feel like dealing with the answer. I'll ask you to go read something. But Moore versus Harper, which the U.S. Supreme Court decided in June of this year, works through this exact problem. And it does leave some leeway for the U.S. Supreme Court to say that a state court decision under, say, the Utah Constitution or state law in general might be sufficiently so non-judicial in its approach to interpretation that the U.S. Supreme Court could review it. But, just as COVID, looking backwards, illustrates how American federalism can work for better or worse, I would say what we're going to watch over the next year is going to do something very similar. So pay attention to it. But just a broader point that is always lurking beneath that question is the polarization point. And I got to say, if I had one thing I could ask every American to do, it would be stop obsessing about the national government, for God's sakes. Start with your family. If you're a parent, how are your kids doing? If you want to move beyond that, go to your community. And if you want to move beyond that, go to your city. And if you have an idea that you care deeply about, make it happen in your city. And if that works through the city council or some other method, make it the rule of your state. But at that point, what gives you the right in Ohio? Why do I have the right in Ohio to start forcing the people of Utah to do what I think is right? Why don't I have the courage of my convictions to say, I've got this great idea in Ohio, we've done it, look how well it's worked, and why don't you try it, but not coerce you? Nationalizing is always coercion. And the problem with premature nationalization is it leads people to be vindictive and resentful. If Ohioans force the people of Utah to do something, do you not think the people of Utah might consider returning the favor? We'll take our pet issue and make the people of Ohio do it. So I'm not saying don't nationalize. The vaccine was a great example of proper nationalization. But when we're not sure, and particularly at a time when we're so polarized, why do we feel this compulsion to nationalize everything? Fix your own home and neighborhood first, your own community, and then people will see if it works, and if it does, presumably they'll adopt it. They're not all fools like professors that drink sanitizer. I thought I'd end there because I know where I started and where I end is, I'm afraid, all I communicated. Professor Brogdon, I let you down. All they know is this guy from Ohio drinks sanitizer. But this was several years ago, right? I mean, of course, you're probably saying, Jeff, it's starting to show. Thank you very much.
Thank you so much, Jeff. We now have a 5-minute break before we come back, and you're going to hear from some UVU undergraduates and some folks about work we do with Oxford University and the work we're doing here. So 5 minutes, and we will see you back. Thank you.